Hello everyone, it's Mark and welcome back. In this video I want to talk to you about how and why the state of Florida can suspend your rights as a parent, a husband, a wife, a boyfriend, a girlfriend, a fiance, a significant other. How is that possible? Well, Chapter 394, which is Florida's Baker Act statute, allows the state or the facility, which is an agent of the state, to temporarily suspend your rights to make decisions for your loved one. So if you're a mom and dad who's called me and want to know why the facility is not speaking to you, why you're not able to make decisions for your minor child or your adult child, or if you're a husband or a wife or whatever, and you're calling me and asking why is it that I can't make decisions for my loved one? Well, the simple answer is because the state of Florida has authorized facilities within the state to suspend your right to make those decisions. And so you're not going to be able to make medical decisions for your loved one. You're not going to be able to decide who treats them or where they get treatment or what medicines they do or don't get. That's what the Baker Act does. That is the potential danger of the Baker Act. And I've talked about in other videos that I think it's a useful tool in the right circumstances. But it allows facilities to temporarily suspend your rights to make decisions for your loved one. Now, normally that suspension is good for 72 hours. And after 72 hours, one of two things have to happen. Either the facility has to let your loved one go, or they have to run to court and get a court order. But that doesn't always happen. And why is that? Well, it's possible that your loved one is not there on an involuntary basis. What do you mean by that, Mark? What I mean is perhaps you've signed some paperwork where you've agreed to keep your loved one there. It's called voluntary admission. And there are times when you won't even know that you've signed paperwork. Recently, I had a family member who was asked to sign paperwork, and on the top of the paperwork it said, that basically they were agreeing to give up their constitutional right to own a firearm. But when you read the document, it talked nothing about that. It talked nothing about firearms. In fact, what it was a voluntary admission agreement. I had another instance where a family took their loved one to the emergency room, and the person at admission said, held up like this iPad, thing and said, sign here, here, and here. They never explained to them what they were even signing. And in fact, I think when they asked, they said, it's just an agreement. You're just agreeing to treatment. And what it was a voluntary admission agreement. And if you agree voluntarily to allow your loved one to seek treatment at a Baker Act facility, guess what? There is no 72-hour clock. It's not ticking. There's no involuntary admission. There's no running to court. And it's a way for the facilities to sort of skirt the concept of getting a court order, of going and asking a judge for permission to keep your loved one. And so your right as the parent, the mother, the father, the husband, the wife, the fiance, whatever, not only has it been temporarily suspended, it's going to continue to be suspended unless you do one of two things. Either, you're able to get the facility to capitulate and let your loved one go, or you're willing to fight and take action, whether you're willing to go to court and force the facility to let your loved one go. Because there are certain requirements for getting somebody to agree to voluntary admission. There are certain requirements for somebody to be involuntarily committed. There's a burden of proof that has to be met when a facility goes to court. Are their pleadings even technically correct? I mean, there's 125 odd pages in the Baker Act statute. It's very convoluted, it's very complicated, and I can tell you that every time I read it, I learn something new. But if you're wondering why that you can't make decisions for your loved one, whether it's your child, your husband, your wife, your significant other, whoever, that's why. It's because Chapter 394 of the Baker Act statute permits these facilities to temporarily suspend your rights. And if you want to change that, then in all likelihood you're going to need to go to court. And that's where we fit in, and I can help you to do that. If you have any questions, feel free to reach out to us or email me or go to our website. We give a lot of content away for free. With that said, thanks for tuning in. See you in the next video. Bye-bye.